The Supreme Court term that just ended included an extraordinary run of victories.
Well, this was a big one, wasn't it?
For the Trump administration.
The Supreme Court has delivered a monumental victory.
Most of that action took place on what lawyers call the court's emergency docket. When presidential administrations file these applications, they are almost always because some lower court judge has blocked one of their major initiatives. And on more than a dozen occasions, the administration raced to the court on issues like immigration, birthright citizenship, transgender rights, the independence of executive agencies. And in that emergency setting, the court generally gave them what they wanted. The volume is way out of proportion to earlier administrations. In just the first few months of the second Trump administration, they filed 19 emergency applications. That's the same as over 4 years of the Biden administration. And then if you go back a little bit longer, the comparison is astounding. Over 16 years, 8 of Barack Obama, 8 of George W. Bush, there were only collectively 8 emergency applications. We're used to thinking about the Supreme Court as a slow-moving, deliberative body, and that's true in most cases. The emergency docket is something else entirely. It jumps into the case on very thin briefs with minimal deliberation and gets decided in a matter of weeks with orders that contain very little reasoning and often none at all. The court likes to say that it's not political, but the emergency docket seemed to result in lots and lots of 6-3 decisions along partisan lines. When you look at the merits docket, the more traditional way the Supreme Court decides cases, the cases that were argued and where the court had a chance to really digest and consider them, the picture was mixed. The court decided 56 merits decisions this last term. Only 10 of them were 6-3, and only 6 of those split along partisan lines with the Republican appointees and the majority of the Democratic appointees in dissent. And that probably tells you that time is the court's friend, that if you give them a chance to consider and deliberate, they might be more apt to find common ground than on these emergency cases. It's true that these orders on emergency applications are temporary and provisional, and it's at least theoretically possible that it returns to the Supreme Court and they ultimately find that the challenge program was unlawful. But in all of that time, people will be kicked out of the military because they're transgender. People will be fired from executive agencies, and it's probably too late for a lot of those people.